At the Geneva Academy, we have 2 research projects to support the implementation of the declaration, one on the rights of peasants more broadly, and one on the right to seeds in Europe more specifically. In the context of this latter project, we participated earlier this year in the public consultations on the EU seed marketing reform, and we're also organizing a series of webinars to discuss these issues in different national contexts in Europe. So we had one earlier this year with Italy, and today is the second one this year. So here's how we'll proceed today. First, Christophe will explain what are the obligations of the EU and its member states in relation to the right to seeds under the declaration. Second, Fulya will explain the interface, the links between the UNDROP and the EU seed marketing reform. Third, we'll hear from Danish stakeholders. So first from Simon von Siebenthal from Danish Seed Savers, and then from Anders Borgen from Landzaten. And after that, we'll open up for discussion. So just a couple of technical points before we begin. For those of us who have our mics on, please remember to turn it off when not speaking to avoid background noise. Please try to keep to the time limit so we make sure we have time for discussion at the end. And finally, we would like to record this meeting. So if you don't agree to be recorded, please let us know. You can send a message directly to Fulya in the chat. Okay, so I think that we're ready to begin, Fulya.
Okay, thank you very much. So what? So it's it's a pleasure to be with you today. So we have this project at the Academy on the rights of peasants since 5 years now, and I've been working on the right foot since 20 years, and on the rights of peasants since at least 10 years. And so we are trying to support this process at the European level. What I will do is that I will quickly present the history of the declaration, and then the main article on the right to seeds, which is Article 19 of the declaration, and then Fulya will present how this can be used in the lobby work on the EU reform of the rules on seeds. So I will just share my screen. So we have this project on the right to seeds in Europe. I have sent the link on the chat, and we have a few publications on the right to seeds in Europe. So we have a long academic briefing on the right to seeds in Europe that we have written with Fulya, in which we explain what the right to seeds is in the declaration, what are the tensions with intellectual property rights, and then we have a whole 2 chapters on the main challenges to the protection of the right to seeds in the European Union. So of course it's a lot more than what we will discuss today, which is the seed marketing laws. Okay, but there are many other things that could be done at the EU level on that. And then we have also produced a summary on the right to seeds in Europe, also with Fulya in October last year. And so it's a few pages on a policy brief on the right to seeds in Europe that you also can use. Now, if we come to this declaration that was adopted in 2018. So it all started with La Via Campesina, 2001 already. They discussed the idea of having a declaration on the rights of peasants. And since then, since 2001, La Via Campesina has been pushing for that at all levels. It started in Indonesia when they had the meeting in 2001, and then they discussed it in all countries in which they are. In 2009, La Via Campesina adopted their own declaration on the rights of peasants. And then there was the food crisis of 2008, and the UN was very interested in discussing these issues. And so there was a process, and it ended, let's say, with the negotiation of the declaration that started in 2012. negotiation of this declaration from 2012 to 2018. It was a 6 years process at the United Nations, and finally the declaration was adopted in New York on the 17th of December 2018. So what is important for us to understand is that the right to seats, the article on the right to seats, we will see it's Article 19, has been really one of the most discussed article and controversial article. And it is also why many European states were against the process of elaborating this declaration at the very beginning, and why they abstained when the declaration was adopted. So when it was adopted at the United Nations, we had in total 121 states in favor, 54 abstained, and 8 voted against. The EU, most of the EU member states, including Denmark, abstained. 2 voted in favor, Portugal and Luxembourg, and 3 voted against. It was the UK, Serbia, and Sweden. What is important for us is that this declaration has been adopted by the UN General Assembly. So and what it's important is that it invites governments, UN agencies, NGOs to disseminate the declaration and promote its respect and understanding. So it doesn't make any difference with according to the vote of the state. It doesn't say the governments who voted in favor of the declaration should promote it. It says all governments should promote it. So that's one argument that we use to say that all states should not promote it. Another important argument is that it is based on the right to food, for example, this declaration. And the right to food is a human right that all EU countries, including Denmark, have accepted. Okay, so we can say that it is also part of the right to food, many aspects, including the right to seats. Then we have there is the declaration is there. There is a long preambular paragraph. It starts with Article 1 on the definition of peasants. Okay, so a peasant is any person who engages or who seeks to engage alone or in association with others or as a community in small-scale agricultural production for subsistence and or for the market, and who rely significantly, who not necessarily exclusively on family or household labor and other non-monetary way of organizing labor, and who has a special dependency on and attachment to the land. Then it says that it applies to a number of activities: small-scale agriculture, crop planting, livestock raising, pastoralism, fishing, forestry, hunting, gathering, etc. For us, what is important also is that Article 2.4 says that states shall elaborate, interpret, apply relevant international agreements and standards with their party in a manner consistent with their human rights obligations as applicable to peasants. It means that the state should elaborate, apply. Also, for example, intellectual property rights treaties in accordance with the rights of peasants. Okay, that's what it means, this Article 2.4. Then the most important article for us is, of course, the article on the right to seats. So there is this, there is Article 19 of the declaration. The first paragraph is very close to what we can find in the FAO treaty. There is a FAO treaty that was adopted on the plant and genetic resources in 2001. And so it says that peasants have the right to seats, which include the right to the protection of traditional knowledge relevant to plant genetic resources for food and agriculture, the right to equitably participate in benefit sharing, in sharing the benefits arising from the utilization of plant genetic resources for food and agriculture, the right to participate in the making of decisions on matters relating to conservation, sustainable use of plant genetic resources for food and agriculture, and the right to save, use, exchange, and sell farm-safe seed or propagating material. Okay, so that's what we have also already in the FAO Treaty of 2001. And then there are very interesting new additions to the treaty. Peasants also have the right to maintain, control, protect, develop their own seeds and traditional knowledge. States should ensure that seeds of sufficient quality and quantity are available to peasants. at the most suitable time for planting and at an affordable price. States should recognize the rights of peasants to rely either on their own seeds or on other locally available seeds of their choice, and to decide on the crops and species they wish to grow. States should also take appropriate measures to support peasant seeds systems and promote the use of peasant seeds and agrobiodiversity. We know that in most of the states, it is not what has been done in the last 50 years, because states have promoted commercial seeds and industrial seeds. So it's a very clear commitment to support peasant seed systems and agrobiodiversity. There is also a whole paragraph on the agricultural research and development that should integrate the needs of peasants and to ensure their active participation in the definition of priorities and the undertaking of research and development, taking into account their experience, and increase investment in research and development of orphan crops and seeds that respond to the needs of peasants. Okay? And the last one is very, very important for us. It says that states should ensure that seed policies, plant variety protection, and other intellectual property rights, certification scheme, and seed marketing laws respect and take into account the rights, needs, and realities of peasants and other people working in their areas. So it's very explicit. It says that when states negotiate, elaborate seed marketing laws, these should respect and protect and take into account the rights of peasants, including this Article 19 on the right to seeds. So that's on this basis that we have worked with Fulia and Karin in this project on the right to seeds in Europe, and that we have done similar exercises at the national level in other countries, as Karin mentioned, in Italy and France and Romania and other countries. And that we also have organized a big meeting at the EU Parliament in June this year with CVC, the European Coordination of Via Campesina, Seed Savers Organizations, and others. Yes, so that's what we have. What is important to understand is that this declaration really is based on it's an interpretation, if you want, of the right to food. Because when we discussed with the EU Commission in June, what they were saying, the person in charge of this topic at the EU Commission, she was saying, but my lawyers, they said that this declaration is not binding, so we cannot use it. So of course, the declaration in itself is not binding. It's a declaration, it's not a treaty, but it has been used already since 4 years now to interpret the right to food, which is binding for all the states of the EU, including Denmark. Okay. So for example, last year, there was a case before the Supreme Court of Honduras, in which the court canceled what was called a Monsanto law because it was protecting intellectual property rights over seeds. And the Supreme Court of Honduras canceled the law because it was violating the right to food and the right to seeds of peasants in Honduras. And they explicitly used the declaration in the judgment. Okay, so they said, we interpret the right to food, and for peasants, it includes the right to seeds. And so we cancel the law because it violates the right to food and the right to seeds of peasants. So that's what that's how we can use this declaration at the national level, but we can also use it at the regional level. So now I leave Fulia continue with the discussion at the EU level.
Thank you very much, Christophe, for this background on the declaration itself. And I will focus more on how the declaration articulates or can articulate with the rules that govern seed marketing in the EU. So as you've seen, so in Article 19, especially the rights that have been recognized for peasants on seeds are affected by numerous laws. They take a holistic approach. So they are affected by the laws that regulate ownership over seeds, whether these are in intellectual property rights that give monopolies for inventions, so whether plant breeders' rights or patents, but also the recognition of traditional knowledge of peasants and people living in rural areas, and then the conditions to access genetic resources and the sharing of benefits arising from the use of genetic resources. they're also impacted by a plethora of laws that govern plant and seed health. So the goal here is to prevent pests, or that enable food safety. So the regulation of genetically modified organisms, old and new. And then last but not least, and this is a topic that we will focus on today, the UNDROP rights to seeds are affected by seed marketing legislation that only govern access to the market in their essence. But you'll see, and most of you already know, that they actually impact much more than access to the market. So which rights are affected by seed marketing legislation? We like to work on silos in a way, to try to silo these holistic approach and the different rights that have been recognized for peasants. So the first one being the right to save, use, exchange, and sell their own seeds for peasants. The right to maintain, control, and develop their own seeds. The right to have access to locally adapted seeds. The right to participate in decision-making, and the rights to the protection of their traditional knowledge and sharing of the benefits arising from the use of their own seeds. So what are the EU seed marketing rules? I'm going to do this quickly, but if you have any questions, please do not hesitate to ask. So the seed marketing legislation is enshrined in 12 EU directives. Directives are a strange European legal animal in a way. It's a law, it's a European law, but that needs to be transposed in national member state legislation. So it's not directly applicable. Regulations are the more traditional law that people know. Those are directly applicable, and whatever rights and obligations are in regulations, you can actually directly claim them in courts in all EU member states. For directives, you need a national law to do this. Okay, so in essence, because we have directives and we have 12 of them that are divided by crops, groups of crops and species. So you have one regime for cereal seed, one other for vegetable seed, for ornamentals, completely different, forest reproductive material, completely different. But all of those 12 are actually transposed in the 27 member states. So you end up with 27 national seed marketing regimes in the 12 different crop species that are regulated. So it's a bit of a spider web in a way, but in that spider web, you do have a general principle that guides legislative action, which is usually that these rules, so these directives, require that there's mandatory pre-marketing registration. Usually it's the variety that needs to be registered before you can sell the seeds that you produce from that variety. And sometimes it's more the operator that needs to be registered. For instance, this is the case in ornamentals. And then these directives also legislate on the quality of seeds. They have rules on the production of seeds, so distances, etc., the absence of pests in general, and then labeling measures, packaging measures, and control of all of these rules. They were enacted mostly, the big ones, so the cereals, beet seed, oil, fiber, etc. They were all enacted in the 1960s, and the goal here was to ensure the identity, quality of the seeds, but also productivity objectives for industrial agriculture. So we're post-war, in a reconstruction, in a context of underproduction. And although all of the directives have been amended numerous times, their initial premise and their objectives have not really changed. You've had, I think the mention of biodiversity only came And so the links between seed marketing and the loss of genetic diversity or its importance only came mid 2000s. Okay, so with the inaction of a derogatory regime on conservation varieties. Before that, it was all about productivity, identity, quality. That's the goal of the legislation. So how does that relate to UNDROP? Is that because of these regimes, so the national seed marketing rules, you have peasant seed systems and their rights are only enshrined in derogations to the system because they're not part of this industrial seed system. And they're impacted two ways, the most important ones. The first question to ask is the exchange and sale of seed actually equate to marketing? And we have 27 different regimes across the EU, and the approaches are extremely different. So in Denmark, the interpretation is quite UNDROP friendly for in terms of exchange and sale of seeds, because as other speakers today will elaborate a little bit more, non-commercial use of seed is not marketing. But for instance, you look at Estonia, all exchange of seeds, even between non-professionals, equates to marketing. And so that means that you cannot exchange a seed of a variety that's not registered. And if you're talking about cereal seeds, you need to follow the very stringent requirements of seed lot certification to be able to produce the seeds and sell them. So it's an extremely derogatory barrier to entry for peasant seed systems. And then the second big question is, do you have a marketing system for locally adapted varieties for low input conditions? So not just based on distinctiveness, uniformity, and stability, which are the main principles that need to be followed in the seed marketing directives to register a variety. So you have derogatory regimes, as I mentioned. So the conservation regime and a variety regime only for agricultural crop species and vegetable species, and the so-called amateur varieties that do not have value for commercial crop production and vegetables. And then the very new organic heterogeneous material regime that comes from the organic regulation. Okay, these are all derogations. So that's why we conclude that there's very little margin of action for peasant seed systems in the EU seed marketing legislation. There's no recognition of farmers' knowledge, and most marketed varieties do not necessarily correspond to their own needs. So right now, this is not the only reason why we're entering a reform, but we are entering a reform of the EU seed marketing legislation, knowing, some of you might or know, that there was a reform attempt approximately 10 years ago that was initiated. So the Commission proposal was published in 2013, but it was rejected by the European Parliament in something that's extremely exceptional. The European Parliament usually works on the proposal it receives and submits amendments. This time, they didn't even want to work on it. So the work started, but the plenary rejected the proposal and asked the Commission to start the work again. They haven't done it until they were requested to work again on the seed marketing file at the request of the European Council. So these are representatives of member states, so heads of government, who requested a study on the options to reform the EU seed marketing legislation in November 2019. What's interesting to note is that on the same day, the same European Council, so the Council of the EU, requested the Commission to also submit a study on so-called new genomic techniques, so what usually people know about as gene editing, so CRISPR-Cas and the like. So the two reform requests essentially came on the same day. I'm only going to address seed marketing, but if you have questions on the new genomic techniques, we can also discuss that further afterwards. For the seed marketing, so there is a study that was conducted by an external consultancy, ICF. They did interviews with a lot of stakeholders. And at the end, in April 2021, the Commission published a working document and essentially said that the legislation was unfit for the European Green Deal and the Farm to Fork. They didn't mention UNDROP, but they did mention that there was a need to facilitate the registration of varieties, especially conservation varieties and traditional ones and organic ones, and to ensure a level playing field across the EU. They mention also conservation and sustainable use of biodiversity, but not peasants as a specific group. Then in June 2021, an inception impact assessment was published with different options for reform that I'll go through afterwards. Then followed by by an impact assessment, which was supposed to finish but is still ongoing, done by an external contractor. And according to the so-called better regulation guidelines in the EU, the Commission needs to assess the impact of any legislative proposal, the impact on socioeconomic and human rights. This is where also the Geneva Academy and numerous other stakeholders have submitted feedback that mentioned UNDROP, but it is still to be seen how that aspect will be assessed and taken into account. The proposal was supposed to be published next month, but the Commission has not been able to find a compromise, and so they had to go back to the raw data, and the proposal has been delayed to spring 2023. I said May, but we don't know for sure when it's going to come, but it's been delayed for at least 3 to 4 months. Okay, and we still don't know whether it will be a regulation with direct effect, so little margin of maneuver to member states, or a directive that needs to be transposed, which leads to very different national regimes, but can also be quite interesting depending on which country you sit at, I guess. And then once the proposal is out, the Council and Parliament, who are the two institutions that hold legislative power in the EU, start negotiating on the text, propose amendments, and then they try to find a compromise so that they can adopt the text. What I'll do now, I'll go quickly through the 3 options that were submitted in the inception impact assessment. I'm going to go through this quickly because we know now that these 3 options are not necessarily on the table anymore because the Commission could not find a compromise within. So they're trying to, I guess, take bits and pieces and elements from each option to come up with a final text. But option 1 was the light reform, so only alignment and simplification. Option 2 was the pathway of flexibility with coherent sustainability. And option 3 is full flexibility, but mostly actually harmonization with high user guarantees and no derogations at all. So for the first one, the idea was that all definitions and all the seed marketing directives would be aligned. I've put everything that's a bit of a threat to UNDROP seed rights in red, and you're going to see the things that are going to come up in green are going to be the positive elements, possibly in light of UNDROP. So the alignment of definitions as they are, especially in terms of decision making, we view that as a threat because there's no participation of peasants in the decision making today, and aligning them will not change it. And there's also a risk that the European Commission gets more power, delegated power, to adopt, so implementing acts and delegated acts, so decrees in a way. And so essentially the entire reform process could be a black box that we don't know exactly what it looks like in practice. The idea of this option is also to align or add definitions for operators and marketing. If you align the definitions of marketing, but it's still a very restrictive stance, contrary to the Danish interpretation, then you might actually have a huge risk of seeing maintenance interpreted as marketing, exchange of seeds interpreted as marketing, and seeing also a mandatory registration of all operators in the seed marketing law, the future law. there's this idea to align the regime of conservation and amateur varieties, not expand it too much, but align it. So it's positive in a way that it could recognize farmer selection. It could provide more opportunities to them to sell their own seeds. And on the other hand, you could also have more locally adapted seeds on the market, because that would create more pathways for non-uniform varieties that are developed, produced, and sold by others. So, but on the other hand, there's no mention of benefit sharing anywhere. Maybe it's not the place, but it should be mentioned. Yes.
5 more minutes.
Okay, I'm going quickly. Then the inspections will be won't be duplicated, so you'll have less controls on organic actors, but you could also see, so if there are less and less inspections, the risk that some peasant organization sees that it could water down the risk assessment process for genetically modified organisms. And they also foresee the increase of tasks that are done and controls done under official supervision. So this is a term that says essentially that you're not going to rely on public authorities to control the variety registration process or the seed quality controls, but it's done by private operators that are supervised by public authorities. So positive thing, you could have more organic testing, which does not happen quite often across the EU, but you also privatize a public service, so which can result in a loss of knowledge and also jeopardize access of small and medium enterprises to the system. They also talk about climate change mitigation and biodiversity measures. So the idea to support and reward sustainable use being a positive thing, but also this idea of sustainable assessment that will be done trait by trait instead of a holistic one, not taking into account social dimensions. And also the same idea is also taken up in the new regime for new genomic techniques, exactly the same way. So with sustainability traits, so there's a risk that everything actually goes against the mitigation of climate change or the protection of biodiversity. The facilitation of registration of organic varieties, this means that you have more varieties on the market, so that could be a positive thing. The option 2, you'll see a little more green. So that's the only framework where the option where there's a framework for exchanging kind between farmers that's envisaged. So this is the most positive aspect, that recognizes seed systems and traditional knowledge that would allow exchanges in the EU. However, it does not, in the word of the Commission, apply to sale, and only would be applicable if peasants are members of associations and not individuals. They also foresee the exemption of sale to amateur gardeners and seed conservation networks. So you could have more opportunities to market exchange, etc. But operator might mean registration. And they also see modern and flexible registration and seed production system with new technologies. So peasants could possibly sell their own seeds according to adapted procedures, their own, and you would have less barriers of entry to the market of smaller actors, so more locally adapted seeds on the market. But mention of new technologies, it's quite unclear what it is. So that's perhaps a risk. And then this idea of mandatory sustainability criteria with what I've said before, so it's not holistic at all, it's only trait by trait. So it might also be a barrier to entry. It's not the holistic approach of UNDROP. And this option you're going to see is all red. So the legislation would apply to all professional, non-professional users. Derogations and exemptions would be kept to a minimum, and everything will be included in the official controls regulation, which is a complete locking of the peasant seed systems. So what do we have with these options? We have a mixed bag with interesting elements, but numerous elements of concern. So the reds also, were more numerous than the green parts. So it is important to engage with authorities to advocate for the implementation of UNDROP and raise awareness of civil society. And I will leave it to the Q&A session to ask what do you think could be beneficial, what is worrying, and what is missing in this reform. And I'm sorry for taking too much time, and we'll leave the floor to
Simon.
Simon.
Simon, the floor is yours. I think you're sharing your screen.
I try and press this button.
Yeah. And you have about 15 minutes, if that's okay.
That's fine. Is my screen shared now?
Yes, it's working.
Okay. Yes, so I will try and tell a bit about the process we were in 2000. It started, I became a part of the process in 2014, 15. The Danish seed savers had already worked with the seed legislation for a few years before that. It was Inger Heyerdahl who was the manager of our political group. I became interested in the seed policy during a Arkanoa workshop that was held, but yeah, and it was pretty. I soon became aware that if we could change our national legislation in Denmark and make sure that we got the best possible implementation of the directives in Denmark, we would actually be in a good position when we would at some point have a new seed law reform. And that this was also what Inger Heyerdahl worked for, and I know that this was also what was taught to many people working with seed policies by Arkanoa, that if we could just now focus in 2014-15 on changing the national laws, this would give us a good platform for where we are now when a new reform is on its way. So what we did in Denmark was, you could say, we were going down two tracks. So we had a campaign. We did a 14 days illegal seed swapping event. So we got a lot of what do you see? What would you say? Public interest. A lot of newspapers and television, and in the end also we got the attention of the minister, the farming minister. For a long time, the Danish seed savers had asked and wanted it to be possible to swap seeds, and we were then promised that this would be possible. Soon after we were promised this, that it would be legal to swap seeds, a new Danish seed law. A few small changes were made, and this was a perfect timing because this gave us the possibility to actually, what do we call it, høringssvar. Can someone help me with this word? Consultation, what do we call it? And answers. So the law was made public, and we had, I can't remember, 14 days or 3 weeks to tell what we thought about it. And we, as part of our illegal seed swapping market, we made it possible for people both to do what we call signatures. So we had people making 5,000 signatures, and we had 550 people and companies writing letters asking this for the seed law to be changed. So we didn't. Yeah, many people wanted like a complete change, or as a change so that it should be legal to minimum swap seeds. We were a group that that went a bit deeper into the subject, and yeah. So we had the Danish seed savers, and I was a part of the Copenhagen Fødevarefællesskab food community. They had 20 farmers as part of the organization. So both to have the Danish seed savers, as you could say, representing the private seed savers, I was interested in also being able to represent the farmers, so that we could say we don't only want it to be legal to swap seeds, we also want a system that is good for the farmers, so that will make it legal to use these seeds in bigger quantities, and also to not just swap seeds but also sell sweet seeds. So a part of the hearing answer was then that we looked at the seed legislation. We looked at the paragraph 47 that says that it a little bit. That says that this law can be put aside if the health of humans or animals are at risk, and then we made clear that it actually looked like with the farming system we have today that the health of both humans and animals are at risk with both temperatures rising and more people demanding food. We actually have a risk for a security risk for food security globally. We also pointed at other places in the directives that actually gave the possibility for a better implementation in the Danish seed law. So we looked at Article 33, 44, 23, and Article 1 and 2. So in short, they are all articles that give different possibilities for either what do we say? To do pilot schemes and to have lower fees and to have to be able to trade smaller amounts, and especially then also in Article 1 and 2. Where we have the definition of what is commercial use. And we pointed out that it maybe could be interesting that we looked at this definition of commercial use. Could it maybe be changed so that it was possible for some actors, for example, the Danish seed savers, not to be considered commercial, even though you could say we are commercial because we are selling seeds. We had 2 meetings with the I need the words, but the official, we say the officials, where many stakeholders were invited. And at this meeting, the first meeting, they came with a proposal that said maybe it should just be legal to swap seeds, but we put an amount on, for example, tomato seeds. We say maximum 5,000 seeds. From our point of view, this was not a good way to do it. I had I proposed that we should not, if we should put these amounts on, we should make these amounts very, very big. So we should say that test amount should be for 40 hectares or something that would fit for bigger populations of heterogeneous material. If we want to be able to save this material, we also need, we can't do it just with a small bag of seeds. We need to be able to do it on bigger scale and in bigger amounts. So the next,
Simon, 4 or 5 more minutes.
Yeah, that's fine.
Okay.
So at the next meeting, I think we were all shocked when this proposal came out from the officials, and this was a proposal to actually have a different understanding of what could say what it's this paragraph 2 as the definition of trade, and that trade should not or commercial trade for commercial use is not trade where the person is selling something to earn money, but it is only considered commercial if the person that buys the seed wants to use the seed for commercial use. And I think we all thought this was a very nice interpretation, and I think many of us has read these sentences aloud for ourselves many hundred times to actually yeah, not just understand them, but also I can't find the right word. Yeah, and at the same time, so this whole document that I'm showing now is a 20 pages document that is not, it's not a part of the law, but it's the official interpretation of the law. So this is actually how the law is used in Denmark, and these 6 sentences are the essence of this law, you could say. The other part, I think that Anders Born will talk more about, is the part with the closed circuits, also the possibility to actually sell or trade seeds within a closed circuit within an organization. That also makes it possible to trade these larger amounts of seeds. There are still no real definition about what these amounts are, smaller or bigger amounts. So Louise, I just find the last document. Louise from the Danish Seed Savers made this small document also, where we were asked what did it do in Denmark that the legislation was changed. I think I had, and many others had wished that more had happened, that even more companies had started using the legislation. But I also think that it's understandable that it takes time when something like this is changed, that we wouldn't see 10 companies overnight starting to propagate material and sell it. But we had the Danish Seed Savers. We have launched a web shop, Fugleberg Jord, that has been selling old varieties for many years illegally. What they did was suddenly legal, and last but not least, Landsorden, a new organization, has started, and I think we will hear more about that now. And I think that's the best, so far the best example of how this law and these changes in the law has had a huge, made a huge difference in Denmark.
Thank you, Simon. That was really interesting. Can I ask you to share this last document you showed in the chat?
Is this the document?
Yeah.
In the English one?
Yes.
Yeah.
So now we'll hear from Anders. The floor is yours. Are you sharing your screen?
I'm sharing my sound. I think you need to.
I see if I can unshare mine first.
Yeah, that'll help. Yes.
I've forced you to unshare.
Am I sharing the screen now?
Yes.
Okay. Yes, I'm Anders Born from Landsorden, and Landsorden is, well, I'm also a member of Danish Seed Savers, but Landsorden, where Danish Seed Savers is mainly sharing seed for private consumers, Landsorden is an organization mainly for professional users. And I will share some of my experience how we have done that in Denmark. Landsorden is created with more or less the same purpose as the plant treaty. That is, that the purpose is to make a diversity of seed varieties available for niche markets. In particular, organic farmers, we started as organic farmers, saying that, yes, we don't have any good varieties for our production. So the purpose of Landsorden is actually to make available varieties and seed that are fit for organic conditions. And in that way, I see it is actually our purpose is the same as the plant treaty. That is also the purpose of the plant treaty, to make a diversity available for farmers. So Landsorden was created last year, but actually the history goes further back. I was also part of the consultation process that Simon talked about. And I'm a plant breeder, and I started my breeding some 15 years ago. So Landsorden is more or less a culmination of this work. We mainly work with cereals. So my experience and conclusions are based on the work for cereals. I know it is different for vegetables. And what we do in Landsorden is that we do plant breeding, or more or less I do the plant breeding. We have also other plant breeders involved, but I'm the main plant breeder. And we do work also with conservation varieties. That means we take out gene bank material and do selections in them and multiply them. And then in this respect, the main question is that we also multiply the seeds and we sell the seed. And this is where there may be a conflict with the legislation, and this is what I will be talking about today. So Landsorden is dealing with all these kind of activities. Can you see my mouse? Yeah, I think you can. So Landsorden is organizing farmers mainly, but also bakers and millers. Actually, the millers is a very important part of the organizations. That since most of the farmers are actually growing grains for the millers. But they're both partners. We have also connection to a mobile seed facility. So that means these trucks, he has 13 of these trucks driving around from farm to farm and help the farmers cleaning the seed. he's not working only for Landsorden. He is also for many others. He also has a mobile mill, so he can go from farm shop to farm shop and make milling to sell home production of flour. We have a mobile combine harvester for small scale production, so we can keep the seed clean. And we also have cooperation with the university in product development. And then I'm the breeder down in the corner here, making the plant breeding. So of course, in this seed system, what is important for us is the regulation for home saving of seed, and of course also for seed marketing, and the seed marketing here the key point is actually the definition of commercial exploitation. Simon talked a little about it. I'll come back to that. Actually, already coming back to that here now. Yes. So the article in the this is the directive for vegetable seeds. So they define marketing as any transfer of seed aimed at commercial exploitation. And this is actually commercial exploitation. This is what changed in the process Simon talked about, that Denmark actually changed our interpretation of this commercial exploitation some years ago, saying that if the buyer is not exploiting the seed commercially, then it's out of the scope of the directive. To be honest, I don't agree that this Article 2 can be interpreted in that way. I think it's quite, but maybe the legal competent authorities have a different opinion. When I read it in a way saying that it is the selling of the seed, it is the that is commercial exploitation and not the end user use of it. But anyway, also the seed industry in Denmark and also in other countries, EU has been consulted, and no one has really complained about this interpretation of the text. So even I may be skeptical. It seems to be agreed that this is a way to interpret the law. So this is what the Danish Seed Savers is using, saying that they are selling only to private consumers, and therefore it is not the seed is not sold for commercial exploitation, and therefore the seed savers have no problem at the moment, and neither do other seed companies selling to private consumers. But Landsorden, we are dealing with farmers, so therefore we cannot use this interpretation to solve our problems, because we are selling to farmers and farmers are buying them for commercial exploitation. So this directive, this interpretation does not really solve our problems. Landsorden is mainly working with cereals, but we also have other crops. And in the directive for marketing of cereal seeds, it says that seed may not be placed on the market unless it has been officially certified. It means all seed need to be certified, and in order to certify the seed, the varieties should be listed on the EU catalog, and there are specific conditions for that. Since Landsorden is working with niche, with small markets, special varieties, spelt and durum wheat, and all kind of special niche productions, it is absolutely impossible for us to meet the conditions in Annex 2. It is out of the question. It cannot be done. So therefore, if you look only at Article 3.1, then our activity is not legal. But there are some new possibilities. There have come new possibilities in the past decades. First of all, the conservation varieties. You can actually approve conservation varieties on very fair conditions, I would say. It's not very expensive. It's not very difficult. So it is possible. In Denmark, we have not used it for cereals. I think the seed savers have approved a few varieties of vegetables, but we have not yet. And then in the new organic regulation in 2022, we have the possibilities for approving organic heterogeneous material, which is also very cheap, even it says almost free of charge. So that's also a very fair deal for us. The problem, when we discussed this with the authorities, and of course in Landsorden we have, I think, 75 different varieties, and they were not too happy to register 75 different varieties if some of them are only grown on 2 hectares. So, but at least the legislation is fine for us. It only is restricted to organic production, but it's not a problem for us. And there is also a possibility for organic bread varieties, which we are not planning to use, because we are mainly working with heterogeneous material where the conditions are much simpler. So we don't really need the last point there. The problem here is that these new, this makes it legally possible to bring it on the market, but we still have no means of financial return in terms of variety protection. So we still have a problem with the financing of the work, especially for the plant breeding. But then
Anders, another 3 or 4 minutes.
Okay.
Is that enough? Yeah.
I will see what I can do. So what we use, and there is so Article 1, Article 3, and point 1 was not really in use for us, but we then turn to Article 3.4, where it says that it is possible that if it is not for commercial exploitation, for example, for test or scientific purposes, then we can exchange seed and we can sell seed for that purpose. And what we agreed with the authorities is that yes, when we are working with varieties that are not officially approved, they have not been tested in official tests. That means that the farmer doesn't really know what he's buying. Therefore, buying small quantities of seed that he doesn't know very well, that is a test. It always involves some kind of test production. And therefore, when we in Landsorden sell small quantities of seed to the farmers, then it's not selling for commercial exploitation. It's actually selling for a test production. And once the farmer has done the test, then he can make a home-saved seed. And so this is actually our system now, that yes, if you want small quantities or the production is very small, then we can sell seed for test production. And if it is bigger quantities, for example, we have two varieties where we grow about 500 hectares. This is not just a test. This is a commercial activity. Then we can register them as heterogeneous material. Maybe I should drop that, but at least home-saved seed is, there are some problems with home-saved seed because we cannot save seed legally of approved varieties. That means varieties where there is a variety protection. And that is a problem in crops where there are only commercial varieties on the market, for example, grass seed or clover seed. We do not have access to seed, to grass seed that are of conservation varieties, for example. So therefore, and we are not legally allowed to make home-saved seed. So here I think maybe there is a conflict with UNDROP. Another thing is that UNDROP only deals with peasants, as far as I can see, whereas most of our members are actually commercial farmers. And peasants, as I see it in the EU, is defined as farmers growing less than 17.6 hectares of cash crops. And most of our farmers grow much more. But so therefore, for me, actually, the plant treaty is just as important as the UNDROP, where it says more or less the same thing. So in my conclusion is that in what we have done in Landsorden is that we have challenged the system. Can we bring seed on the market of these varieties that the farmers could not access before? And the conclusion is yes, we can. The authorities have been very flexible. They have interpreted the legislation in a way that have made it possible. We debate with them, we negotiate. We have been, what the UNDROP and plant treaty also says that they should involve farmers and peasants in the process. And we have been involved, they have listened. And they have actually made it possible. So we have actually been able to market anything that we wanted to market. So I cannot really see that the legislation in our case has been an obstacle. Yes, sometimes we are debating, but they have actually met all our requests. So the problems we have for agrobiodiversity and bringing seed to the markets is not the legal problems. It's more financial problems. In our case, it is cereals and it is organic cereals. So there may be other farmers facing a challenge, but in our case, I cannot really see that the legislation is the main problem at the moment. So this is my conclusion. Thank you.
Thank you very much for this. Maybe I'll just jump in with one question before we open the floor, because as you mentioned, you're part of the lucky ones in Europe, right? And the legislation has not been an obstacle. This is not the case in other European countries. And maybe a word on the concerns you have with this reform process. So do you think you could lose some of the very positive developments you have fought very hard to get, and or do you see opportunities to actually enlarge them?
Yes and no. I would say yes, it has been quite a process. It is possible for Landsorden now to do it, but it has taken 15 years. We have been lobbying and discussing for 15 years, so it was not easy. And it very much rely on the authorities. A few of them are actually present today. I'm very happy for that. And they have been really willing and open to solve this problem. I think with what is on the table at the moment, I think with the help of the authorities, I think we can solve most of the problems. But of course, when it turns from a directive to a legislation, to a regulation, then of course it will be more binding. But what is on the table at the moment, I am an optimist for Landsorden and our very narrow part of the seed regime, but there may be others that have more problems than we have.
Thank you so much for that. Do we have any questions or comments from the floor, from other organizations? Please don't hesitate from any. Yes. Ola, I see that your camera is on. Do you want to comment?
This is not a question to Anders Borgen or to Simon. It's a question to Christophe. Thank you very much for your description of how the declaration came about. Denmark, the way I understood it, did not abstained from voting for the declaration on the basis of Article 19, but the foreign ministries told us that it was because of a lack of clarity concerning the rights of indigenous peoples. That I could not find any lack of clarity in the declaration, and they did not answer queries about where that lack of clarity might be. But that's just a point of clarification, Christoph. Thank you.
Thanks. So maybe I can just say something, because it's very good to know, and I think that you can reply, because we were extremely careful not to touch the rights of indigenous peoples. So indigenous peoples are not mentioned at all in most of the articles, just in the first article, in which it says that, of course, indigenous peoples who are peasants, I mean, the declaration also applies to them. But then it's important.
Oh. He completely disconnected, or is it just me?
No, he's
out.
gone.
Yeah, we lost him.
Okay, but I'm sure he'll come back and finish his thought. I hope so, when he realizes. Okay, I'm seeing him already.
Yeah, sorry, I lost you. So I wanted to share my screen. Can you put me as co-host?
Yes, sure.
Sorry. Okay. So in the declaration, we had put we added this at the moment, at the last moment, just to be sure. Voilà. It's 28.1. Nothing in the present declaration may be construed or as diminishing, impairing, or nullifying the rights that peasants and other people working in rural areas and the indigenous peoples currently have or may acquire in the future. So we added this article 28.1 exclusively to respond to this question, to make sure that the declaration doesn't affect the rights of indigenous peoples. So, and we have no reference to indigenous peoples in the whole declaration. So it cannot be used as an argument. And I think you should write back to the government, because maybe there will be a new opportunity next year. We hope that we will create a new monitoring mechanism at the United Nations. And so on the rights of peasants. And so there will be a vote by states, member states. And so there will be another occasion for states to take position. And so I think that it's very important to respond when they put such argument. But thank you. It was great to know that it was not because of Article 19.
That's right.
Any other comments, questions? Yes, Erling, please.
Here I am. Little busy, it seems like. I participated in this working dialogue group with the officials regarding making this seat swap legal. And maybe this can help some of the other countries. As I remember this group, when I saw the change in the eyes of the officials, it was when Mr. Kofod, Thor Gunnar Kofod, the guy that is the head of the commercial seed producers in Denmark, one of the third or fourth meeting, he said, this is not a problem for us. The private seed savers are not a threat to us, so just go ahead. And I think that was basically what changed the attitude, and that everyone could relax, because the Danish agricultural system is very influential in Denmark. And I totally agree on Anders that we had a very good dialogue and very good discussions, and the officials were very nice. But in general, the Danish agricultural department is not easy to work with. I'm working with the patents, and there's no way through, as I see it now. But I think that if you are in another country and you could get hold of the commercial seed producers, if you still have someone left we have in Denmark, but maybe not in all countries. And you could convince them that this is not a problem for them, that you swap seats on a private level, then I think then the governments would be more positive and not be that nervous for reactions. Thank you.
Thank you very much, Erling. Any other comments, questions? I'm trying to respond to some questions in the chat. Yes, Christoph, please go.
No, just so it's a more a question to Anders, who presented that the fact that you have a definition of peasants in Denmark, so it's not the case in many countries in which we worked. So you said that there is a limit according to the size, and so most of many are not peasants, and so the declaration doesn't apply to them. That's what you mean?
No, I'm sure it's a EU definition that we if we use seed of a variety that are protected by variety protection, then for cereals we are allowed to use home saved seed, but we need to pay to the seed owner, to the variety owner. But if you are a small-scale farmer, you are exempted for paying this royalty, and that is as far as I know, a European regulation.
Yeah, but it's small farmers; it's not peasants. So
No.
I'm going to play the terrible lawyer here, but it's not the definition of peasants. And the declaration also applies to people living in rural areas. So it's more encompassing than just small farmers defined in the community plant variety system, which is very, restrictive. You also have actually another definition of small farmers in the support scheme for agriculture and development under the Common Agricultural Policy, which is not the same size. So you have different definitions of small farmers for different laws in EU. So,
Yeah, this was just the only definition I could come up with. And it's just to stress that, and maybe you can answer that, whether UNDROP only deals with peasants, or is it also rights for commercial farmers?
No, of course. If we come back to the definition, it's peasants, and as I said fully, other people working in rural areas. But it's true that then in the activities in which they can be involved, it's small-scale agriculture. But again, what is small-scale depends.
Well, I'm sure that most farmers in Denmark are not defined as small-scale farmers.
Okay.
I mean, if you have a billion krona industry and growing several hundred hectares, you are not a small-scale farmer. That is the general situation in Denmark.
Okay.
I think what's also interesting maybe to highlight is that, the human rights are awarded to peasants, which is a smaller group of population. But since these people have the right to have access, to locally adapted seeds of their choice, I think the declaration impacts the entire seed system, because it puts an obligation to the states to ensure that peasants have access, so they can find on the market varieties or populations that are adapted to their needs, and not only varieties that are adapted to industrial crop production. So it has this indirect effect on the entire seed system, which pushes it to diversify the seed offer on the market.
Yes, I very much agree, and that is the main problem with the EU seed legislation. It is not the specific paragraph for the individual farmer. It is the impact that the seed legislation has on the whole seed system that creates problems for the individual farmer, and that is a major problem. But it also has obligations to support local seed systems, even in research and in other ways. For Landsorden, I can say, yes, we applied for a project, a nationally a research program, and we were granted. So now we can say, yes, we did actually get public support for our seed system. So also in this way, the authorities have actually been positive and met the criteria in UNDROP, that they are actually supporting us.
Let them do so in Brussels, please.
Yes, but we still have I mean, it's still the problem with biodiversity on the global scale and agrobiodiversity in Europe, that the seed system is not sustainable, and it also has impact on the access to seed for farmers.
Any other comments, questions? Please. We can take a few more. Yes, please. Lars?
Yes. Hello, can you hear me?
Yeah, now we can. Yes. We can also
Can you see and hear me?
Yeah.
Well, I'm Lars Landbo, and I represent the Danish Agricultural Agency, and I'm almost embarrassed by all the nice words about the Danish authorities. I'm of course glad for that, and I just wanted to say that I mean, we listen to everybody. We listen to the seed. We would like to listen to the seed savers as well as to the conventional agricultural organizations, and it will be important in the upcoming negotiations that we identify the sticky issues and decide how we can what the Danish position should be in order not to jeopardize the systems that we have created in this country, as you mentioned, Fulja, that we obviously need to be alert in the upcoming process. So we will try to do that. And thanks to the organizers for organizing this very interesting meeting and drawing our attention to the UNDROP, with which I must admit I was not very familiar. Thank you.
Thanks to you for attending and for taking the floor. Anyone else want to react, or should I give the floor to Christophe or Karin to?
I can't find the hand button.
Please. Yes, please, Simon, conclude, and then I'll give to Karin.
No, I just wanted to ask you. You asked us if we were fearing this process of a new seed law, and I would like to ask you: should we fear this process?
I mean, there's an eternal optimist in me, so I think honestly, maybe not as much as Anders, because I mean, I'm part of the Brussels bubble in a way, and you can't be an optimist in the Brussels bubble. But honestly, it's very different than the 2013 reform. The European Commission knows that they cannot not disregard or put to the side all the worries about the conservation and sustainable use of biodiversity, that they need to listen to a wider range of stakeholders. This was not the case 10 years ago, and now they really listen. I mean, the conference we did in June, there were 6 people from Commission services, and they listen more. But that doesn't mean that the commercial seed industry and the seed market has its own needs and also fears, that are going to take precedence, perhaps, on certain issues, because it is a very, important market and segment. So, yeah, optimist with caution, because you never know what might happen.
I don't know how to get in on showing this hand, so I'll show my own.
Please go ahead. Yeah.
Am I allowed to speak?
Yeah, sure.
Okay, but I'm not at all into. I sit in the same committee as Simon does on the farming ministry, but as I must admit that I have put my mind other places. I'm doing a soil food web education for myself, and in that respect, I've been trying out Anders Borgen's old seeds, and they seem to work a whole lot better with the microbial community in the soil. So to put it shortly and bluntly, you can say that in Danish we call it fremavl, as a forward breeding, when we are breeding seeds to have new better grains or whatever. And really, it is not forward breeding. It's our egenskaber, what's it called? It's you're breeding off abilities of the plants to communicate with the microlife. It's a serious consideration here, because the plants are actually able to feed themselves if they have the right microlife around them. That ability we plug away when we are enhancing breeding after just high gluten content or low gluten or anything else content. Because we are breeding in a soil that hasn't got any microlife anymore, it's dead. And then we put artificial nitrogen in, and that's all our breeding happening that way. And every time we get a plant that put more seeds in the kernels, it's because they don't waste the seeds on feeding the microbes in the ground, which is very important if it needs to have something in return from the ground. So I'm a little bit disappointed with that. I can make research on two fields exactly the same. Anders Borgen's field gave 21% extra yield for 30 kilo of compost made into extract and sprayed out. The new grain varieties on the other side of the fence did make nothing different. So I'm a little bit worried that all this about, we think we're so brilliant, that breeding is a big hoax.
Yes. Hence, maybe I'll just make a quick link then with the seed marketing. That's my worry with the sustainability assessments. So the way the European Commission services, so they need to do the sustainability checks now and integrate this into any legislation. There's also a framework coming on sustainable food systems, but that system, so the framework legislation takes a holistic view, so it looks at the system itself. And here in the seed marketing legislation, or also in the new genomic techniques legislation, it's only about traits, so looking at, or is it pest resistant? Is it does it allow you to use less water? So you check a list instead of looking at sustainability in a holistic and systemic fashion, which, not only I think does not go hand in hand with UNDROP, but also with the Sustainable Development Goals or the international treaty or other international obligations.
So when you go to GMOs, you never know what you hang about. And with 200 unintended consequences for every one you put in intended, well, I don't know what can be right in those seeds.
Thank you. Closing words, Karin?
Just wanted to say thank you to the presenters and to everyone. I learned a lot from listening to you about the situation in Denmark. And I have to say it's heartening to hear about positive developments in Denmark, because that's not the case everywhere. And I hope we stay in touch in the coming months as the EU proposal comes out. So thank you.